and the jury returned a verdict of $17,300. Our 998 a week before trial was $35,000. Basically, she's getting nothing because everything's going to cost.
Right. I was going to say, civil go into trial on $17,000?
No, they asked for like 3 or 4 million or something like that, like they always do.
17,000. Well, the lawyers got the money.
Well, no, because they're going to have to pay our cops bill now, which will probably be right around 11. No, probably be right around 15,000.
She got negative money.
Basically, plus she still technically owes all the lien money for all the lien doctors. And her one doctor alone was like $60,000.
So she's homeless now, essentially.
I got a hotel open today. It was kind of cool. The hotel was open. Yeah, there was one of our clients they bought a hotel and
Nice.
it's funny, the hotel is up and operational.
Oh, really?
You got a hotel, you're running it, I want to buy it. You sell it to me, I can't get a business license, I can't get a permit. What the hell? We got to come out, we got to inspect it. It was just running.
Yeah, for real.
Oh, and they've been battling the city of Palm Springs for months. They ultimately hired us to come in and, after giving us some runaround, when they had a meeting with the city attorney. We just need to make this happen. You don't want the suit. You don't want the suit. It's just, at this point, that's all we have left is to file the suit.
Yeah.
And got the building inspector out there this morning. Got the business license this afternoon, and they think I'm freaking awesome. I do nothing. Just threaten a lawsuit.
It's how you threaten. It's how you threaten.
I did it really non-threatening.
Yeah, there you go.
This is just going to cost everybody a bunch of time, effort, and money. It was already operational for 5 years with no issues. They've done nothing but throw paint on it.
Which hotel?
It was called the Century. It is now called the Madison or something like that.
Never even heard of it.
Yeah. It catered to a special kind of clientele in Palm Springs.
One of those.
Was it one of the newest places?
No, this thing's built in like 1957 or something.
Well, okay.
I apologize for being a little late here. One of our former students' children got in trouble and we had this. We're good now. So, okay, you're going to be doing arguments here pretty soon?
We're going to be doing arguments. So, Becky, you want to go first? You want to be up and ready? I'll sit over here and take my notes to rebut you, and then, to be the defense, and then
So
you can
stand up there with your chairs, maybe.
I'll just go in there.
Good evening, Will. Good evening, Vincent. Ricker. Let's see what we got here.
He's using all the tricks and tactics he was given last week.
Tripping more off the top of my head with these, go to my blood points.
Let's close this door real quick before you start. Sorry. I just want to make sure you're not interrupted.
So, ladies and gentlemen, jury, you just heard the evidence presented. Jeffrey, he was out. He was working the driveway. He got a jackhammer to help his widowed mother with her driveway, so that she could save a little bit of money on the repairs and the remaking of her driveway. The evidence showed that Rock Industries knew that this particular jackhammer Jeffrey was using was susceptible to jumping when hitting a rock. They knew about this. They told all their people that rented their supplies, they told them, hey, watch out for this jackhammer. It's jumped. There's been several reports that this jackhammer has jumped and landed in one particular report, it even landed on a person's foot, a contractor. and a professional contractor. He landed right on his foot. Fortunately for that contractor in particular, he did not lose the toe, but for my client Jeffrey, he lost his foot. But not only did he lose his 3 toes, he also lost everything he ever had, essentially. He was a firefighter. He was a hero. He would love, he wanted to serve the community. But since the loss of his 3 toes, he is no longer able to perform his job. He has no balance. He can't run into buildings anymore. This is all he's ever wanted to do, and now he is unable to do this. Also, unfortunately, this incident did not happen when he was on the clock, so he does not have workers' compensation. So now he is unemployed, he is injured, and he is lost without his purpose in life of being a firefighter. And he's only looking to be made whole. That was my closing, but I didn't say it in the closing there. Kind of, yeah. Yeah, so.
Okay. I don't think that was that bad, to be honest with you. Very good. I would tell you 2 things. First of all, you have very good eye contact, very good contact with the audience. I mean, you were really covering the territory. That's fantastic. And you should keep that up. Don't be counting with your fingers and stuff, because that's just a nervous habit. When you're going, you did this and that, that just doesn't work. I would just say one thing. About 3 sentences in, you said he lost his toes, and he lost more than that, he lost his job. That would be the first thing I would say. Only because, what you're trying to do is make an impact. And here's how it happened. They told him that he should, be careful, and that this jackhammer had been dangerous before. But so what you want to tell the jury is this ended up in a tragedy for this guy. And here's why it happened: because they were not responsible in giving them the proper instruction, and therefore he's lost everything. So it's just a different organizational pattern. But remember, when you start, you don't want to start off slow and then build up. Better you start off on a high note and maybe go down to the details and then come back up at the end, because they remember the first and last thing that you tell them, the jury. So those are the most important things. Those are the things I would tell you. And I think you covered the territory, because we know what the case is about. And you could maybe put in a little more detail, but you don't need to do much. So it's actually, I know you were looking a little uncomfortable, but it was actually better than you probably thought it would.
Yeah, wasn't bad at all. You had an appropriate level of emotional stuff, right? He's trying to help his mom, wants to be a hero, right? That's all appropriate language. It's colorful, and it's probably, out there. Not every fireman wants to be a hero. We call them heroes, right? And so that's appropriate. So, all right. You want to do a rebuttal?
Not really, but if I have to,
You want to do a rebuttal? I'll give a quick little defense one for you. You can see what you want to do. Sure.
Yeah.
Good.
Good.
Sit down. Get ready to take some notes. Mr. Kent. Right. Rock Industries. I see the plaintiff sitting over here. I see Bond Rentals, my client right here. They want you to focus on Rock Industries. Why Rock Industries? Because if you focus on what we did, we win. And if you focus on what Mr. Kent did, we win. So they don't want you focusing on any of those things. So what would you have a business do? You come in to rent it. We give you the warnings verbally. He couldn't be bothered with that because he's a fireman and he knows these things already, right? Who are we, some business rental company, to tell a fireman about safety and how to work equipment? He didn't need ours. Besides, there was a cute little co-ed he had to go talk to. We then give it in writing. And make sure they understand it. Will you sign this? You saw it. He signed it. We gave him all of the appropriate warnings. And what does this hero do? He goes home and he ignores all of them. He doesn't wear the safety shoes. He doesn't wear the safety goggles. He doesn't wear the correct clothing. And on top of it, let me drink some beer too. Right? So if you focus on what he does, he doesn't win that way either. Right? Bob's rental did everything we needed to do. We provided all the appropriate warnings. The plaintiff acknowledged all of that. And when he took all the unnecessary risks on his own choosing, he's responsible for the outcome. Don't let him benefit from his own mistakes. And better yet, don't punish our client for doing the right thing. Thank you.
Now, before you do it, Victor, you were arguing about Rock Industries, right? Most.
Yeah, I think I forgot to mention that.
Well, I mean, that's okay, because it's more about they're taking on what they know is a dangerous item, right? I'm just telling you, you want to think about that. They're taking on what they know is a dangerous item, and they're trying to get you to believe if you sign some kind of a form, therefore it's okay to eliminate your toes and ruin your job. So I'm just telling you, if you want to figure out a way to get back to them, right?
See what I can do.
Finish strong.
So Mr. Bonds would have you all believe, or would have you all wanting to focus on what they did do, but just to distract you from what they didn't do, which is to explicitly stop this man who was distracted by a lady in the room. Yes, he was distracted, which would make Bonds Industries put the burn on them to put more effort to getting this man's attention and telling him, hey, this is a dangerous piece of machinery. I need you to make sure that you don't, chop your foot off. This is a company that deals with dangerous machinery and should already know not to just give this the industrial grade machinery out to just anybody. They did not tell him, they did not get his attention, they did not explicitly make sure and take every effort possible to make sure that this gentleman would be safe operating this industrial grade machinery. That is what they did not do.
Good. Remember, you don't necessarily always want to just rebut. I thought that was good, rebutting, what I had to say. You always want to have a little bit of reiterating your strong points in your rebuttal. You want to give that, hit a little bit of what they have to say, but finish on what you want to leave them with. And maybe hit them with a little bit of your strongest points from your opening.
I mean, yeah, what he was saying, what I would say is, this guy literally lost his foot, and they're holding up some kind of a paper release and saying it's okay, right? I mean, that's what you have to, your strength is a guy lost 3 toes, right? So you want to say, this guy literally lost his foot, and they're holding up a piece of paper saying, oh, well, it's okay. Even though we knew that this jackhammer had jumped before and caused these kinds of injuries, they say, well, just look at this piece of paper and ignore the fact that he lost his foot. Do you think that's fair? Do you think that's right? You get what I'm saying?
Yeah.
So you want to come back at him with whatever you have, and you want to try and contrast, what they're saying. I mean, Pete did a good job of saying, you should have done this, you should have done that, you should have done that. And what you want to do is go right at it and say, so yes, they have this thing, and he has 3 toes missing. Who's the worse off for this? You know what I mean? And you can't mention insurance, but everyone knows that insurance is paying this, the company's not paying this. So you got to figure out some way around this. I mean, it's not going to harm this company to pay, what it takes to make this man whole again. And come on, otherwise it's a horrible outcome. They say nanny, nanny, nana, and he walks or limps away or hops away, with nothing. So I'm just saying, you want to. I'm into. For after years of argument, you always want to go, well, what can you do with this? So, on the spot, that's the kind of thing that I think would make a difference.
And I your rebuttal, I could see the emotion. I could see a lot more passion in you, and that's what you want. That's what you want to bring to your argument. That's the time to bring it. Because right, when you're, especially if you got an emotional case like you do, bring that emotion to your close.
And I would say, never let him forget this guy lost half his foot. However you want to say it. I mean, because if you think about it, if a person really thinks about this, my God, half my foot's gone, and they're waving paper at me saying I should have known better, you can make a big deal out of that. And of course, that's your best argument, right? Is your injury itself.
Yeah.
Gentlemen, thoughts on Victor's performance? What do you think?
Very good. You did a lot of eye contact, and it wasn't as scripted, which probably made it a lot better than what mine's been.
It really did. It just does good in presence. You really do. I mean, I know you're nervous and you're sweating and all that, but I mean, you're present. You're making contact with the people you're talking to, which is a really good thing because that's what sells.
And you're really good at short, sweet, and to the point.
Yeah. It's really important.
All right.
Here
we go.
Hell hath no fury like a man scorned. I believe the evidence presented to you in this case has proven this beyond a reasonable doubt. The defense wants to paint the defendant as a broken family man who is trying to make his marriage whole, a man who was over his extramarital affair, and one who has no recollection of the events that took place on October 5th of 2017 because he was having a standing date night with his wife. However, the evidence and testimony have shown that this simply isn't true. The defendant in this matter has been charged with 2 separate offenses that you have been tasked with deciding. The first is operating a motor vehicle while under the influence of alcohol, and the second is leaving the scene of an accident. To help you in deciding that the defendant is guilty beyond a reasonable doubt, I want to give you the Reader's Digest version of the evidence that shows each of these counts should be decided as guilty. Soon, the judge will read to you jury instructions in this matter that will tell you what must be proven in order to find the defendant guilty of these acts. In regard to the first count, which is operating a motor vehicle while under the influence of alcohol, you, the jury, need simply find that the defendant was driving a vehicle while under the influence of any alcoholic beverage. The state has proven this count through the testimony of Ms. Kevins and the investigation done by Officer Jackson. Ms. Kevins testified that when she was driving home the night of October 5th, she noticed Mr. Grifford, a fellow math teacher and a person whom she was having an affair with, pull up beside her, try to open his window, wink, and blow her a kiss. Now, you may be thinking to yourself, why did Mr. Scarella just say that he tried to open his window? Well, let's remember that Ms. Kevins testified that he appeared too drunk to remember how to roll down his window. Now, we could simply take Ms. Kevins' word that the defendant was drunk, but I'm sure any jury would reasonably require more evidence than a layperson's testimony that the defendant was drunk. We then must look at the report written up by Officer Jackson. The officer notes that the defendant had a strong odor of alcohol in his breath. He had bloodshot and droopy eyes, his speech was slurred and thick, and that he was unsteady and swaying. Additionally, by the defendant's own admission to the officer, he had 5 glasses of wine and 2 martinis. Further, Officer Jackson asked the defendant to undergo a breathalyzer test for the presence of alcohol and a field sobriety test. The defendant refused to undergo the breathalyzer test, and he ultimately failed. Officer Jackson then placed him under arrest for driving under the influence of alcohol. Therefore, I believe the evidence clearly shows that not only was the defendant operating a motor vehicle, but that he was under the influence of alcohol while doing so. Next, we must look at count 2, which is... No, go ahead. No. Next, we must look at count 2, which is leaving the scene of an accident. Here, the judge will tell you that I need to prove 3 things. First, that a person was involved in an accident. Second, that the person knew an accident happened and that they were involved in it. And third, that the person failed to immediately stop or failed to give his name, address, and registration information to the victim in the other car. I'm going to walk you through these, what the judge will call elements, step by step. We can join the first two elements together as they're tied together in the accident. Ms. Kevins testified that after the defendant failed to be able to roll down his window, the light turned green, and he stepped on the gas, swerved into Ms. Kevins' car, hitting her on the left front panel of her car. Further, Ms. Kevins testified that the defendant stopped and gave her the finger. This shows the defendant knew that an accident happened and that he was the cause of it. Finally, had the defendant stopped and exchanged information with Ms. Kevins, this count would not be an issue, but he didn't. Ms. Kevins testified that instead the defendant, after flipping her off, drove away without even getting out of his car, or at least attempting to. I'm sure the defense will come to you after I'm done and try to tell you not to believe Ms. Kevins or her testimony, and will try to paint her as a psychotic woman who projects her own fantasies onto others. He did this during direct examination, and I believe he'll do it again during closing arguments to you. However, there are some parts of that doctor's note that I want to draw your attention back to. First, Dr. Strong noted that his interview was far too short to make any conclusive diagnosis. And secondly, he stated that Ms. Kevins is fully capable of returning to work and will in no way be a risk to the workplace. Now, we also need to take this note in the context of when it was, in the context of when it happened and look at the circumstances in a reasonable light. The defense wants you to believe that Ms. Kevins was projecting her fantasies onto the defendant and that the defendant and Ms. Kevins, and that she could not gauge the appropriate level of intimacy. However, we need to remember that the defendant and Ms. Kevins were in a mutual relationship that they both admit to, that they both admit to having. This was not a one-sided relationship, and this is a relationship that was. This was not a one-sided relationship, and this is not a relationship that was purely imagined up by Ms. Kevins. This was two consenting adults who decided to be with each other. Further, taken into context, Ms. Kevins was in a very stressful position at work. She not only worked with the man she was having an affair with, but she was also working with his wife. She would have to see these people day in and day out and had to give off the feeling that her relationship with the defendant was simply that of coworkers. I do not think anyone can blame Ms. Kevins for having a minor work-related breakdown. In fact, the defense would want you to believe everything Ms. Kevins has to say about him because of this. The defense wants you to disbelieve everything Ms. Kevins has to say about him because of this report. However, the report was written in June of 2017, and the relationship wasn't broken off until August of 2017. Therefore, apparently, the defendant had no issues continuing on in this relationship with Ms. Kevins and didn't find her crazy enough to end things. So you have to ask yourself, why now is he trying to make a big deal out of this minor work-related breakdown? The answer is simply he's trying to use any information he has available at his disposal, illegally obtained or not, to shine this negative light on Ms. Kevins, and you should not be fooled by this ploy. The evidence shows, both your testimony and the testimonies of Officer Jackson and Ms. Kevins, as well as to the arrest report, that the defendant was not only driving under the influence of alcohol on the night of the incident, but also that he caused a collision to occur that he did not stop and share the required information needed under the law. Therefore, I ask that when you go back to the jury room and begin your deliberations, that you come to the conclusion that defendant, Mr. Grifford, is guilty on both counts. Thank you.
Good job. You're ready to go, Will? Sure. Let's get it on. We'll make some answer when you're both, huh? Unless you want to do a rebuttal after this.
I do have them.
Okay.
On the day Mr. Grifford was arrested, he said, "I did not do it." Later, at the police station, he spoke with the police freely, no reservations, and he said, "I didn't do it." Yesterday, he sat before you He looked you in the eye, under oath, and said, "I did not do it." Moreover, Mr. Grifford has an alibi. He was at home since 4 p.m. And he has a witness to this alibi, Mrs. Grifford, who sat before you, looked you in the eye as a woman cheated on by the defendant, and said he couldn't have done it. He was at home since 4 p.m. Ladies and gentlemen, you are here for one reason. You are going to decide A, guilty beyond any reasonable doubt, or B, not proven. That's it. That's your job. Mr. Grifford is accused of 1 DUI and 1 hit and run, which are both alleged to have taken place on Saturday, October 5th of last year. The day before, on Friday, October 4th, Mr. Grifford got into a car accident in the parking lot of the high school where he works. He pulled over, he paid the other driver, and settled the issue. No hit and run on Friday is alleged. The next day, on Saturday, the date of this alleged incident, Mr. Grifford had a scheduled standing date night with his wife. These were scheduled standing date nights every single Saturday. So on Saturday, like every other Saturday, Mr. Grifford was at home. The only time he left the house was in the afternoon. In the afternoon, Mr. Grifford went to the store, he got stuff for dinner, including alcohol, and arrived back home at about 4 p.m. The couple had their date. They drank alcohol together. They ate dinner together. They watched movies together. They spent quality time together. By 10 p.m., they were a bit intoxicated, but they were at home. Mr. Grifford did not drive intoxicated. He didn't drive anywhere. It was at this time, at about 10 p.m., that Mr. Grifford saw a police officer feeling parts of his car. You learned that the officer was feeling parts of his car to determine if it had been driven recently. And what did the officer tell you? He told you that neither the hood nor the tailpipe were warm. No evidence the car had been driven. If Mr. Grifford arrived at home in the period alleged, the hood and tailpipe would have been warm. There would be evidence that Mr. Grifford drove. But no, the tailpipe and the hood were not even warm to the touch. This shows you, this proves to you, that Mr. Grifford told you the truth yesterday when he sat before you, looked you in the eye, and said, "I did not do it." But with the officer in his front yard, Mr. Grifford went outside in a bathrobe with a martini and asked the officer if there was a problem. The officer told Mr. Grifford he was investigating a hit and run that occurred that night, an hour before, at 9 p.m. Mr. Grifford informed the officer that the previous day he was involved in an accident with a black SUV, but on that day he had been home since 4 p.m. Then Mrs. Grifford came out and completely independently told the officer that Mr. Grifford had been home since 4 p.m. and got into an accident the day before. This is when Donna Kevins appeared, the alleged victim in this case. Driving a blue car, she screeched in, screaming and yelling obscenities. She charged at Mr. Grifford. She hit him, and the officer forcefully placed her in the backseat of his police cruiser against her will. Ladies and gentlemen, this is not the conduct of a stalking victim. This is not what stalking victims do. Why did she go to the house? She had already called the police. Why didn't she let them handle it? Why does she want to confront Mr. Grifford? Does she want to see him? She's not being stalked. She wants his attention. Now, about Donna Kevins. Both Mr. Grifford and Donna Kevins are math teachers at the high school. And last year, Mr. Grifford had an affair with Donna Kevins. This is the real mistake Mr. Griffith made, getting tangled up with Donna Kevins. We learned that Donna Kevins has a mental disorder. Donna has delusions. It's sad, but really, the only evidence the prosecution can present is testimony of a woman that's suffering from delusions. I told you the prosecution's fairy tale is fantasy, and I'm saying it again. Only now you know why. The prosecution's fairy tale is literally Donna's delusion. You're here to say either that Donna's delusion is proven beyond a reasonable doubt, or they're not proven. And no, they're not proven. They're definitely not proven. Also, we learned that Donna's delusions are triggered when she misunderstands her place in relationships. And in late August, 6 weeks before the incident, Mr. Griffith broke it off. He chose to work on his marriage with his wife. Then, Mr. Griffith gets threatening letters in his school mailbox, where both him and Donna's delusions work. Who sent these? Do you not know? Really? The problem is that this man went back to his wife and left behind a histrionic woman who's suffering from delusions. Back to Saturday, October 5th. Mrs. Kevins was probably hit by someone that night. That person probably left the scene of the accident. And she immediately, at 9 p.m., called the police and reported the incident. Then at 9:50, 15 minutes later, nearly an hour after the incident, she called the police again. And this time she said Mr. Griffith did it, and that he did it intentionally. She gave the dispatch operator Mr. Griffith's address, and the police responded, as they should. The officer went to Mr. Griffith's home, and Mr. Griffith came out drinking a martini in a bathrobe. The police officer arrested Mr. Griffith. Why? Because he was drinking a martini in a bathrobe. It's not a good look. Still, the fact that Mr. Griffith was in a bathrobe with a martini actually shows that he was at home. It does not show that he got into a car accident, then went home and tore off all of his clothes, then concocted, as the prosecution said in opening, a coherent story with his wife involving marriage trouble, scheduled standing date nights, driving to the store at 4 p.m., dinner, movies. Oh, and then he had a fresh martini ready to go when he calmly walked outside and talked to a police officer. And then Mrs. Griffith calmly walked outside after getting this big story and calmly told the police officer that he had been home since 4 p.m. Who concocted a story here? Really? Perhaps it's the person that suffers from delusions? And yesterday, Mr. Griffith looked you in the eye and he said, "I did not do it." Now, in order to find him guilty, you have to find him a liar. You have to find that he lied to the cops twice and to you yesterday under oath. Also, you have to find his wife a liar. You have to find that she lied twice to the police and to you yesterday under oath, all to protect a man who cheated on her. Also, you have to find Donna's delusions to be the truth. The truth beyond any reasonable doubt. Donna's delusions are not the truth. Ladies and gentlemen, you're here to decide whether Donna's delusions are proven beyond a reasonable doubt or not. That's it. And facts presented prove that Mr. Griffith was at home the whole time. He was not guilty of DUI because he was not driving. And he was not driving because he was at home with his wife. He is not guilty of hit and run because he didn't leave the scene of any accident. And he didn't leave the scene of any accident because his accident occurred the day before. But Mr. Griffith did make a mistake. That mistake was Donna Kevin's. It's very simple here. Ladies and gentlemen, you check the box that says not guilty, and you go home and you work on your marriage. Thank you.
Insult the jury.
You gotta go?
Oh, sure.
I know, I sat there yesterday and said I didn't do it, and then I stand up here today and say I did do it. Ladies and gentlemen, remember in opening statements when I told you that you would have a chance to hear the story that defendant and his wife concocted? Yes, I said concocted to the officer on the night of the accident. Well, you've now heard it from start to finish. When you retire to the deliberation room and you're determining whose testimony to believe, I want you to remember the defendant's story and remember it with an eye towards common sense. The defendant wants you to believe that Miss Kevins was so heartbroken that she was in a random accident and decided to blame the defendant to get back at him. But let's look at what this would have had to have required by Miss Kevins. Miss Kevins would have had to have known that the defendant's vehicle was involved in an accident the day before, that he did not have the car already towed for repairs, that no police report was done on the prior accident, that the damage to Mr. Kevin's car was on the correct side of the vehicle to match the damage to Mrs. Kevin's car. That Mr. Kevins was home drinking to excess. Let that sink in. In order for the defendant's defense to work, that he was home all night long on a date night with his wife, and that Miss Kevins vindictively accused him just to get him in trouble, she would have had to know all that information. It's not plausible. Further, put this in contrast with what the defendant and his wife had done so far to try and bolster their story. Supposedly, the defendant's wife did not know about this affair, yet she decided to steal the doctor's note from Mrs. Kevin's personnel file. Supposedly, the defendant ended their relationship and was being harassed by Miss Kevins. But we have phone records that show that the defendant was calling Miss Kevins at all hours of the night. And finally, we have the defendant's handwritten, unsigned note that just so happened to still be in his jacket pocket that he had to send his wife home to get, that were supposedly left in his work box. Where are the reports from the school showing that he had received further reports and opening an investigation to why he was getting these reports? There are none because there were none. And finally, the defense wants you to believe that an emergency tow call wasn't answered until 24 hours after the phone call was placed to them to come pick up the car. Ladies and gentlemen, I'm not here to tell you which version of the facts are correct and which ones are incorrect. I'm just simply asking you to use your common sense while deliberating to determine the correct verdict. Thank you.
Good.
Both of you did very good. Very good. I want to start with your rebuttal first. Loved it. Absolutely loved it. There was more fire, more, I like that you left stuff back that you didn't talk about in your opening argument. You let him go ahead and talk, and then you slapped him with it afterwards. I really like the way you did that. In your opening argument, you had that continuation of your theme, which I thought was good. And then right away you start thinking, well, starting with the defendant will tell you you don't want to open your argument talking about what the defendant's going to say, right? Do that at some point, but not right out the gate. And Will was kind enough not to object when you said, I believe the evidence shows, right?
No.
No personal opinions.
Right.
Right, stay away from that. And, you know, I know you had a lot there that you wanted to get through. The second half, it looked like you were reading, where your first half, it didn't. Right, the first half you were flowing, you were clearly checking your notes, but then you popped up and you were going. Second half, you were light on. You're reading a lot. Rebuttal, again, excellent in my opinion. I thought you just really addressed those concerns very well. And I hope you recognize if you had made that argument in your opening argument, what do you think he's going to do?
Right.
He would have addressed it.
Well, that's why.
Right, he would have addressed it. So I like that you didn't do that and you saved that for his vote. Now he's sitting over here, gosh, dang it, because he wants to say something, but he can't. He's done. Excellent rebuttal. And you want to go, Vincent, or you want me to?
Let me just say two things, because I've only got two things to tell you, Vincent. If I'm not mistaken, you gave all of the field sobriety test results and all the stuff, but that was when he was already home, right?
Yeah.
So I think Will had a great opportunity to say, there's no field sobriety test at the scene of what it's supposed to be at DUI, and this is drinking a day after driving, according to what he said. So I'm just telling you, you better watch out for that, because I was waiting for Will to say, well, he's talking about a field sobriety test when he's been home drinking for 4 hours. That's not when he was driving, and that's the charge in the case. So I'm just saying, you know, when you gave it, I immediately thought, well, that's not when he was driving, so why would you be telling me about that? I would have sort of left that probably. On the other hand, Will did pick it up, and it's no big deal, but I'm just saying when you're talking about DUI and you're proving DUI by a field sobriety test, and you're saying, if the story is right, this is after driving.
But it was at least, he had definitely had something to drink between.
Yeah, you know, a lot.
Yeah.
Yeah, and I mean, that's
Right.
what I would have said. Look, this is drinking after driving. This has nothing to do with driving. And actually, it was 24 hours after the driving that involved the accident. The other thing is, then this is just a stylistic thing, the Reader's Digest version. I don't even think anybody knows what the Reader's Digest is anymore.
I was going to say Cliff Notes, but I was like, I don't know if older people on a
What
jury
I
would
would say is something like this. This is a different stylistic thing. You heard the evidence. I'm just going to talk about the highlights. So it's the same thing,
Yeah.
except remember the jury is the one that decides. So if you say, you heard the evidence and you have to go back and deal with it, let me just cover the highlights for you. It's a way of pushing the decision-making in their lap, respecting their decision-making, but still saying, I'm not going to cover every bit of testimony. So that's just a little thing. And let me just see if I said anything on the rebuttal. I thought the rebuttal was great because you say back stuff, which was, you would have to believe this, you'd have to believe that. I think that's it. So it was just little things. Otherwise, both of you are fantastic. Literally better than lawyers that I see who are in the courthouse doing arguments on cases. So this is really good. So I'll leave it at that.
You'll see DAs that have been DAs for years not give a rebuttal like that.
Yeah.
Who will stand up and say, well, the defense said this, that's not true, this is it. And we'll just literally go over the defense's whole argument, point by point, and try to counter it.
And the opposite end of the spectrum, by the way, is the people that stand up and just give their closing argument again. They don't even mention the defense. I mean, really, it's more common than you would believe that they don't even mention what the defense said, and they just go back and say what they said the first time. And so I mean, there's both ends of that spectrum that happen, and you really cut through that. That's really good.
Well, I thought, wow, I mean, your presentation was very, very good.
Really.
Eye contact, your presence, your voice modulation, you went up, you went down. I really liked it. I love the beginning. I did not do it. 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 I thought that was an excellent opening. Oh, and it's also got an alibi. And then you just methodically went point by point by point. why he's not guilty, okay? And at one point, I made a note here. He never said stalking.
Right.
You use that language. I wouldn't have called her a stalking victim. I wouldn't have used that language. I wouldn't have even reminded the jury about stalking. And he may have come up in his rebuttal and brought something like that up. And there's nothing you can do. And that's where, as a defense attorney, you're kind of at a catch-22. It's like, well, I know they think she's a stalking victim, but he didn't use that language in his close. Do I bring it up? Or am I going to remind them about all that evidence that really cuts against your client? That's a tough call, right? Do you use it or not use it? When you said it to me, it didn't match your flow, right? You wouldn't, I think you're better off just not even acknowledging, address, she's a so-called victim. I wouldn't have probably used stalking. You talked about her delusions, and then I really like the way you modulated. You were going fast and loud, and then you slowed down and soft, and I thought that was great. And then for kind of no reason out of nowhere, seemingly you didn't need to do it, you seemed to pick a fight with the cop, right? Why did the cop arrest my guy? Oh, because he's wearing a robe and a martini. You had such a good flow, it seemed like potentially you're going to turn somebody off with that, right? I don't know, how did the cop come across as a witness? If he came across as a credible witness, and the really two issues is only between the parties, you're making it sound like he's dishonest because he didn't do his job, right? So that kind of struck me as sharp and a way that you didn't necessarily need to go unless that was there. But I absolutely loved it. I thought everything about your argument was good, and that's what you want. It was, okay, the guy's guilty. Wait a second, no, he's not. You gave a very good close.
That's what a good trial is about, is when they shoot, you bounce back and forth based on two good lawyers going back and forth on the evidence. Let me tell you two things. After you told me 3 times I didn't do it, why did you tell me not proven versus he's not guilty?
Right.
Because maybe that's just a lawyer, maybe the jury wouldn't pick that up, but I would say, well, then tell me he's not guilty.
Right.
That's the verdict you want, right?
Yeah.
And so, and I get it, we always try to fudge a little bit and say, well, he was not proven, it's not guilty.
Right.
But wouldn't it be better to just say he's not guilty?
Probably.
Yeah. And it's a little thing, but especially when you're dealing with jurors who've never seen a trial before, not proven doesn't mean much to them, unless it's one of those cases where you're saying, geez, it could be so much, that's to be more, almost for sure true, whatever. If you're doing all that business, maybe. But in this case, you're just saying, he didn't do it. He's not guilty. That's what at least that's just a little thing. And by the way, this is all in the context of it was a fantastic argument. The other thing is, I would have done a little stylistic thing, and it relates to what I was saying about, he tells you about an FST, which happens, in nowhere near the time of driving. I would say, this is a case of drinking and driving 24 hours before, drinking 24 hours later, and that's not a crime, or something like that, because it really was, because he didn't bring it up, but all the fields of writing test, all that stuff is afterwards. Then I would have done this. You just sort of fluffed over. She got to the house with her blue car and ran up and hit him. Right. I'd have said, she got to the house, screeched her tires, got out of the car, and ran up and physically assaulted him. Because that's really what you want to establish, right? She's a nutcase. Why does she come there and physically assault him when she's already reported this to the police? What does that mean? What does that show you about her? I would have made a big deal of that, but that's just, just hit him. It's like, but like physically assaulted him sounds really bad. Right. And in fact, the officer had to put her in his car to keep her separated from him. I would have thrown that in too, because as I recall, that's what he did, right?
Right.
Wouldn't that have been a really big deal to say, God, she's nuts? They had to drag her off of him and put her in the car. Might even have said that. Now, obviously, there's all kinds of things you could say about that, but I think the fact that she showed up and physically assaulted him is really pretty important. You know, if she's a stalker. And I mean, I don't know, how did the stalking part go again? You were saying they're trying to say that he's a stalker?
She says that he's a stalker. He says that she's a stalker based on, she says she broke it off. He said he broke it off, and they're both saying they both couldn't get over it.
Right. So of course, if you ask who's demonstrating the stalking, maybe it brings up the phone calls. But who's stalking who, you know? And you don't have him showing up at her house, but you have her showing up at his house. That sure to show she's the goofy one. I love the delusional stuff. I think that was very good. And I would say ending the idea of going home and working on your marriage.
It's not something I wrote out. I just like.
Only because the statistics, 50% of the people are getting divorced. So working on your marriage might not be a good idea. And I get it, you're throwing it, but you might say, you know, maybe you would contrast her behavior to his behavior and say, pretty clear, and he's the guy who's said described the same thing. And she's the one who made it up 50 minutes later, 50 minutes later. All in all, excellent. I mean, really excellent. And these are just little stylistic things and little differences. But man, oh man, you guys really did a job.
All right. Well, now we got some good news for you.
Here's your mock trial new case thing. Okay, pass it on. We'll pass one down to Pete too, and I was gonna walk down there and give it to you, but okay. We're very well organized. So this is what the kids are working on, and it's a really good case because it's a faults report and a 422.
Now, are we going to have them for witnesses and?
I don't know yet. I'm a little lost on this, and we might not. And the other thing is, I've got a backup, which is some of the kids want to come over and do scrimmages.
Okay.
Which means that we might get them that way. So I'm going to have to work on that because there's a little lack of communication with us, and David Gustafson, who's the principal over there, and I think it's because Alana went over and started working with Chandi, so we sort of lost our communication. But I'll get that straightened out.
Okay.
But what I would like to suggest is maybe we should all read this and then come back next week and maybe work on just walking through this case to see, you know, what are the issues. I think between Pete and I, we could probably identify the issues and the issues that relate to each of the crimes here. And maybe that would help you guys to get focused on what's going on.
Yeah, and just so you know, here's where you're at procedurally with the class. We do still have some more lectures coming up about pretrial motions and trial notebooks and things like that. But the expectation is you're going to be an attorney in this case. You're going to prepare pretrial motions. You're going to prepare trial notebooks that you're going to turn into us. You're going to conduct this entire trial, motions, opening, directs and cross, closing arguments, you know, start to finish. So, you know, that being said, keep this in mind. Have a thought in mind about how you want to attack this. Do you want to be the people? Do you want to defend Mr. Klein? What we have done in the past is we put you up in teams so you can share that workload because, you know, preparing a trial can be a lot of work. So if two of you want to work together, the other one gets stuck with me, but I carry my weight, you know. I do my part, and then you know, you really got to start wrapping your mind around everything that's going to be required of this. Okay, and
well, and the other thing is we're going to ask. we've invited some of the students to come over and do their mock trial and their scrimmage stuff. So if you want to, and we usually do that on Monday and Friday, but we might do it on Thursday as well, we can have you go watch them. And you can learn a lot from what they come up with too, because they've got coaches that are other lawyers as well. So in the end, this should be really a pretty slam dunk kind of thing for you. But it'll be all the way through from pre-trial motions all the way through the closing arguments. And I think it'll be an excellent experience because you'll actually get to see yourself do it, but you'll also have some help with witnesses and stuff like that. We'll recruit the kids from Amistad or wherever, if not Amistad, from whatever one of the other schools. So we'll have witnesses. It'll be just about as close as we can get to a trial without having you in a courtroom.
Yeah, and
But I'm telling you, you guys are doing great. And I wanted to also mention to you that you don't have a midterm on Saturday, so we're giving you a break. I think we have loaded you up with 2 PTs and 2 Wilson Trusts, so you will be writing a lot. But in the end, after all this is done, this is what you end up doing. So we're giving you a preview of coming attractions.
And it's we had a lot of fun. Every time we have that final trial,
Yeah,
it turns out to be a lot of fun.
it's very good.
Being Dolan's the judge, and you guys are objecting and getting rulings, and and you got to live with them, right? You want that report in? Well, he just told you can't get it in. So there goes your whole delusion argument. Now what are you gonna do? Well, you're thinking on your feet
Yeah,
about it. And I just prepped this whole case, but that's my theory, and now it's gone. So you guys are gonna get the pretty close to real life experience. And what's kind of good about the kids is, right, it's an act for them, right? They've got their script just like you guys do. And so you'll get some genuine, I don't know. I don't know. And what are you gonna do with them?
Refresh
Right?
their record.
You're gonna refresh their recollection,
Yeah.
you're gonna approach and can I show you this and all of that. So you'll have exhibits to mark and introduce.
and this is just, again, technical stuff, but we're going to do it in the courtroom. So then you have to sort of have your game plan done. How do you approach a witness? What do you do when you approach a witness? Where can you go in the courtroom? Because there's just little special things like you can't go in the well and stuff like that. So we want to get it as close to real as we can. And at least our experience the last few years this has been very interesting. So, boy, if this is any indication what you did tonight, this is going to be good.
Yeah.
Really good.
There was a lot of good arguing tonight. I especially like that defense argument in Kent v. Bond. That was fantastic.
Fantastic.
Yeah. Unassailable. Well, I think this is great. I just love watching you guys because you're that close to just getting out there and doing this. And it's a pretty cool thing to see.
You said you've seen some trials.
I have seen these trials, yeah.
So how do you rate yourself?
I have to see myself. I've never seen myself give a speech.
I thought you looked good.
Yeah.
You did. Granted, you're between chairs and whatnot, but you were moving, and I thought posture was good. And I thought
Everything. And you really had a great start. I mean, really, that's the kind of thing we're looking for. He said he didn't do it. And you repeated 3 times, and all of a sudden it's like, wow. So this is the case. He didn't do it. It's really good. Really good. No messing around, ladies and gentlemen. How are you? So nice to see you this afternoon. Just right into the stuff. I thought that was great.
Victor, we didn't even bother to ask you.
No, I did love I didn't do it. The first thing I noticed was like, wow, he's really planting that seed in me. There was a lot more passion. So.
Hey, Grifford goes home.
No, he doesn't. He's going to jail.
Well,
Actually, it's a misdemeanor. He's probably not going to jail. He's probably still going home regardless.
As far as the jury here, I think you got a hung jury probably.
Yeah.
Because I really like the rebuttal. It's swayed me back.
Yeah. It was good to save a little something there.
I always like to, and we talked about this last week, but to the extent you got something good you want to say, and you don't want to give them a chance, say it in rebuttal.
Well, I originally had it in the original, and then I was like, no. Well, say something.
There's a corollary to that that's really important, and it takes a long time to learn this. For witnesses, be careful about asking one question too many. So, you can get them right up to the point where you could say, so isn't it true that you're a big damn liar? And they're not going to say yes. So just get it up to that point and then stop. Because when you get to whether it's an opening for the prosecution or the defense, there's no witness that can come back and explain it away now. So it's a corollary to that as well. So, if you ask the cop or if you ask the person the last question, then they explain away the problem. Don't give them a chance to explain away the problem. And it takes a while to get the feel for that, but it's really important because it makes a massive difference on what you get out of the witnesses.
I guess I should have given you guys 2 arguments for tonight.
One's good.
Yeah.
Yeah, you're fine.
You guys got a lot of reading for next week.
Yeah.
Right?
Yeah, so let's all be really good and familiar with this
Yeah.
case by next
Let's
week.
go through the packet. If you look at your syllabus, I think it says next week is closing arguments round 2. Replace it with, this is your reading. We'll get our assignments down next week, and we'll start identifying issues and what you need to do going forward.
And then just as a heads up to you guys, next Thursday I'll be here. The Thursday after that, I'll be here for half the class.
Okay.
And then the Thursday after that, I'll be on the camera.
Where are you gonna be?
In Vermont.
In Vermont, so cool. Yeah, well, that'd be.
Hopefully
he's all
Really good.
Ready.
Come over there, it'll be really fun to check it out.
Yeah, that should be good. So,
All right.
Thanks, Professor.
see you guys.
Keep safe.
You're gonna be in class at like 10 at night, so like.
From 9